Hi, this is Scott Pierce. Welcome to our Torts seminar. In this seminar, we're going to review one of the most important subjects on any bar exam, and we're going to focus our attention both on the black letter law and on our analytical and writing techniques that will ensure that you're going to do your best if a torts fact pattern comes your way on the upcoming bar examination. Please take out and review with me our approach to this subject. You'll notice that I present both a minimalist approach and a more elaborate approach. The reason for this is to give you a clear idea about the big picture of this subject and then focus a little bit more on the details. Take a look at the minimalist approach. It asks, first, that we evaluate how the plaintiff has been injured. What we want to do is identify as many practical complaints our plaintiff may have as possible. And remember, think like plaintiff's lawyers. Every possible injury we want to claim on behalf of our clients. Next, we want to consider who is responsible for that plaintiff's injury. And on the bar examination fact patterns, the quick answer is the plaintiff is going to consider suing everybody else in the fact pattern unless the call of the question narrows our focus a little bit as to the defendants. Third, we consider the plaintiff's theory or theories of liability. And here what we're trying to do is spot the issue, and then we're going to break it up into elements and carefully discuss each element. Next, we consider the defendants' defenses. And in these seminars, we always are going to pay close attention to the defenses, because in the real world, that's been my work as an attorney. And as a defense lawyer, both in civil court and in criminal court, I appreciate the role of the defense. And on the bar exam, I think it's really important to be aware of how the defense thinks also. We've got to be prepared to present both sides of any given story. Finally, in our short approach, we consider remedies. And you already know, I am remedies-centric. I think remedies is the most important subject on any bar exam. The California exam in particular, but also nationwide. We're going to focus our attention carefully on remedies. Remember, remedies doesn't have to be that complicated. The big picture of remedies includes damages, restitution, and equitable relief. Okay, that's the big picture. Now let's focus our attention on the elaborate approach. First, again, we concern ourselves with the plaintiff's injuries. And what we do is, basically, we come up with a laundry list of specific facts that the plaintiff is going to allege constitute redressable harms. Then, after that, we consider who's responsible for the plaintiff's injuries. And remember, we're always going to think about the named defendant and perhaps everybody else in the fact pattern if there isn't a named defendant. Next, we consider the theory or theories of liability, mindful of the fact that bar exam essay questions often test theories of liability arising from more than one subject. So, although, of course, our attention in this seminar is going to be focusing on torts, we're also going to be aware of contracts and property as principal sources of remedies issues. And we're going to see how these issues play out and are tested together across the different subjects. But here in torts, at this point of our approach, we incorporate an outline of the substantive law. And though the material I present here is not necessarily intended to substitute for your own understanding of the black letter law, I do want you to see how I organize it for essay purposes. First, we consider torts against the person. These are the intentional torts, including assault, battery, and false imprisonment. Now, obviously, you need to know the definitions of all these theories of liability, but you don't want to present elaborate boilerplate definitions in your answer. The reason is we want to use the elements of the theories of liability as headings, as organizing principles. Next, we turn to intentional torts to property. These include trespass to land and trespass to chattels, and also conversion. Next, I create a category called intentional injuries to intangible interests. If you've learned this material in a different format, please stick with your own format. I just want you to understand how I consider these issues. If you've got an organization of the black letter law in your own mind that works for you, don't tamper with it. But you'll see under intangible interests, I include IIED, the business torts, which often can be a crossover into the law of contracts, defamation, which itself can be a crossover into constitutional law, and I include slander and libel, and we'll be focusing on the defense of the First Amendment. It's often a defense to defamation. Next, we consider invasion of privacy, which is not itself a theory of liability, but rather it's an umbrella that covers several theories, including commercial appropriation, false light, public disclosure of private facts, and intrusion on seclusion. Please keep in mind that these theories of liability often are tested all at the same time, and our job is to distinguish them from one another. Next, I consider strict liability, negligence, nuisance, and products liability. We're going to have a look at all of these theories of liability in quite a bit of depth in this seminar. Products liability is something that I want to stop on briefly as we consider an approach to torts. Products liability also is an umbrella, not a theory on its own. So within the umbrella of products liability, we've got strict liability, negligence, and warranty. And the rule of thumb is, on a products liability hypothetical, you should consider all three theories of liability, and oftentimes we're going to be called on to distinguish how one theory relates to another, comparing different defendants. Finally, we consider the defendants' defenses. The big picture is a fairly small one. We consider privilege, contributory or comparative negligence, and assumption of risk. In the end, we consider remedies. And remember, remedies is the heart of every bar exam, especially in California. So we consider, first, damages. Remember that damages are designed primarily to make the plaintiff whole, to compensate the plaintiff as best we can with money for the injuries that the plaintiff has suffered. In torts, punitive damages also are available, and the multi-state will do a very good job of testing your knowledge about which theories of liability engender punitive damages and which don't. Next, we consider restitution. If under damages we're concerned with making the plaintiff whole, under restitution our focus is on the defendant. Here, we want to prevent unjust enrichment of the defendant by using the restitutionary remedies. These include replevin, in California known as claim and delivery, and also constructive trust and equitable lien. I promise we're going to have a very good look at these issues before we're done going through torts and contracts, and especially remedies. The last type of remedy that is commonly tested in torts is injunctive relief, an equitable remedy available to plaintiffs who are able to show the appropriate need. And I break down equitable remedies the same way every law professor in torts and every bar review expert has done. We focus on the inadequacy of the legal remedy, the plaintiff's property right at stake, the feasibility of an equitable remedy actually working, balancing the hardships, and then defenses. Under defenses, the defendant can replay his or her defenses to the substantive theory of liability, and additionally, there are defenses that are specific to equitable relief. So remember, in torts, our primary job is to identify the plaintiff's injury, come up with the plaintiff's theories of liability, and then to break these theories of liability up into elements and to connect the facts from the fact pattern with the elements of the theory of liability, or elements of a defense, or elements of a prayer for relief. A complete answer to torts considers both the harm, the redress of the harm, and the defendant's defenses. Ultimately, we've got to conclude concisely as to the bottom line with regard to liability. So good luck on these torts questions. By the time you've made your way through them, you will have obtained a very thorough review of the law, And also, you'll have quite a good idea about how the Committee of Bar Examiners tests these issues.